Minister Edwin Tong.
With your leave, I will address members' queries on the disbursement of unnominated CPF monies and leave the rest to my colleague, Minister Tan, to deal with everything else. So I thank members for their comments and suggestions. I believe the broad thrust of the speeches made by members have been supportive of a more expedited process to disburse unnominated CPF funds, but some questions have arisen as to the process and how we safeguard the integrity of the disbursements, which I understand. And I'll deal with the questions raised by Ms. Ng Ling Ling, Ms. Henny So, Mr. Saktandi Supat, Ms. Mariam Jaffa, Ms. Herting Ru, Mr. Louis Ng, and Ms. Joan Pereira on this point. Ms. Ng and some members raised concerns that there could be a lack of recourse in cases where the beneficiary representative, whom I shall call BR, does not exercise fairness in distributing the deceased unnominated funds or unreasonably withhold the funds from beneficiaries. So Ms. Ng has raised some questions concerning the application process, how to identify the BR, how the public trustee intends to ensure the welfare of the remaining beneficiaries. Mr. Supat sought clarifications on whether the policy will serve to benefit the family of members who did not name any nominees. He also asked who is eligible to be a BR and what is the specified limit. Mr. Supat also asked about the BR process, whether it could simplify and speed up the distribution of unnominated CPF funds. Ms. Jaffa asked about the recourse that next of kin may have in the BR approach, and Ms. Herting Ru sought clarifications on the specified limit and how it will be determined and whether it may be changed over time. So let me first broadly outline the purpose of introducing the BR approach in this case. It is, as I mentioned earlier, to simplify and make easier and facilitate the beneficiary's claim through the distribution of unnominated CPF monies via the BR. And also to facilitate the beneficiaries, the speed at which it can be done, whilst at the same time managing and mitigating the risk of disagreement or conflict which might arise between the beneficiaries. And to be clear, by beneficiaries I refer here to those who are eligible for and entitled to the deceased CPF members' unnominated monies under the Intestate Succession Act for non-Muslims and the administration of the Muslim Law Act for Muslims. The BR approach will therefore benefit these eligible beneficiaries of the deceased CPF member. As a comparator, the BR approach in this case that we have introduced is not an entirely new concept. Members might recall the proper claimant approach adopted by the CPF board, which applies to cases where the nominee passes away after the deceased member the nominee passes away after the deceased member has passed away and before the CPF funds could be distributed to the nominee. The CPF board pays out the CPF monies due to the nominee to a proper claimant who is a party that claims to be entitled to the monies or assets. So the concept and process is similar and in some ways modeled on the proper claimant approach. We have considered the operation of that scheme and also thought about the issues of potential abuse that could be mitigated and addressed in this current BR scheme. And so we have introduced various safeguards to ensure that the beneficiaries' rights and interests remain protected. Let me now address them in the context of members' questions. To answer Ms. Ng's question on how a BR is identified, and also Mr. Saktiandi's question on who is eligible to be a BR, let me first explain that a BR is not pre-identified by the PTO, the Public Trustee's Office. It's not pre-identified from the list of eligible beneficiaries. Rather, letters are sent out to the deceased CPF members' next of kin and the individuals who reported the death to invite them to submit a claim. Upon receipt of the letter, the eligible beneficiaries of the deceased can come together. They can then amongst themselves identify and choose a representative. If they can all agree on that, that is the one representative that will come forward on behalf of this pool to make the claim and receive the payments from PTO. If the eligible beneficiaries, however, cannot agree on a BR or do not wish to appoint one, or is unable to come to an agreement as to how to distribute the unnominated CPF funds amongst the eligible beneficiaries, then the current claim process will apply. So we'll default back to the current position. It will be a little bit more complicated, more forms need to be filled up, more information has been provided to PTO, but it will safeguard the process where there might be some disagreement between the beneficiaries. The PTO will also carry out the following steps to safeguard the rights and interests of the eligible beneficiaries, and this addresses Ms. Ng's question on how the Public Trustees intends to ensure that the welfare of eligible beneficiaries will be taken care of. It will be a requirement of the application process for the BR that the eligible beneficiary applying to be the BR must declare that he or she is either the sole beneficiary or that he or she has obtained the consent of all the other beneficiaries which the BR is seeking to represent in making the claim. The PTO will then confirm with the other eligible beneficiaries directly that they have given their consent before the PTO pays out any unnominated funds, CPF monies, to the BR for the BR's onward distribution to the other beneficiaries. In addition, upon receiving the information, PTO will also undertake independent checks to verify the eligible beneficiaries' details provided by the BR against existing available existing records. So do a bit of due diligence to cross-check the information, to cross-verify the information provided by the BR. If there are discrepancies, the PTO might require further clarification or further information before dispersing the funds. To Ms. Jaffar's question, in cases of dispute over the nomination of the BR, the eligible beneficiaries may seek recourse by informing the PTO of a dispute. If that happens, the PTO will not proceed with the application for the BR to distribute the unnominated sums. It will instead discuss with the eligible beneficiaries and see whether some consensus or an agreement can be reached, failing which, again, we default back to the current standard process, as I mentioned earlier. If, despite these steps taken by the PTO to weed out these cases, there might be situations where the BR receives the unnominated CPF funds before the disputes are surfaced, and subsequently there are disputes over how it is dispersed or the manner in which it is done, the eligible beneficiaries can seek recourse against the BR directly under the law. So the new proposed Section 225, capital A7 of the bill makes it clear that any recourse that any person might have against the BR for any amounts paid out by the PTO to the BR are not affected even after payment of the unnominated sums by the PTO to the BR. On Mr. Saktiandi and Ms. Hurst's question on the specified limit, I think Minister Tan earlier mentioned that the specified limit will be set at 10,000. Besides the PTO's actions taken to safeguard the rights and interests of the beneficiaries, the framework is inbuilt with a safeguard to only apply to cases where the deceased member's unnominated sums do not exceed this sum. This specified limit, in our view, strikes a balance between expediency in the disbursement of the funds and safeguarding of the beneficiaries' rights and interests, particularly in the context of larger estates. A specified limit of 10,000 would allow around half of the current cases, half of the current number of cases coming forward to make a claim for unnominated sums. And we believe that of this half, a substantial number will be uncontentious and will benefit from an expedited scheme like this. To Ms. Hurst's question, the specified limit can be reviewed and adjusted in the future if necessary to allow more people to benefit from the BR approach. But we suggest we let this run for some time and iron out any rough spots before we look at adjustments subsequently. With the various safeguards put in place for this new BR approach, eligible beneficiaries in appropriate cases who have consented to the BR receiving and distributing unnominated sums can benefit from this simplified and expedient new process. Both Mr. Saktiandi and Ms. So asked how the approach will assist in simplifying and speeding up the process. Apart from what I mentioned earlier, let me highlight that the BR approach only requires the BR to provide proof that he or she is the eligible beneficiary with all the beneficiary's details, including his or her own. The BR need not submit proof of eligibility of all the other beneficiaries, so this cuts down part of the administrative time and effort. The BR approach also relieves the other beneficiaries from administrative inconvenience, and by and large, in the majority of these cases, there is no disagreement, as I mentioned, and in such a situation, particularly amongst family members, the facilitation of the disbursements can be much faster. Once the PTO receives confirmations, as I've outlined earlier, from all the eligible beneficiaries and the verifications are done, the application can be approved. In our estimation, the unnominated CPF monies under this scheme could be disbursed to the BR within about 2 weeks from the approval of the application, as compared to a much longer period of time under the current standard claim process. Ms. Jaafar asked about the efforts made to contact and facilitate the disbursement of CPF monies of a deceased member to Singaporean family members who might be overseas, especially in light of the current continued travel restrictions and the ongoing pandemic. As the PTO oversees the distribution of unnominated sums, I will address this point only on unnominated sums as far as the PTO is concerned, where the member did not make a nomination. In such cases, PTO will take steps to reach out to the deceased member's next of kin, regardless of whether they are residing in Singapore or overseas. Using the next of kin's last available address registered with the NRO, the PTO will write to the next of kin using that address. Obviously, its efficiency is subject to whether the address is accurate or whether it's been updated. If the overseas address is not registered, then PTO will rely on the next of kin's, the member's next of kin to provide the office with any available alternative information. Deceased CPF members next of kin who are residing overseas can also choose to contact PTO to inquire about the deceased CPF members' unnominated CPF monies. The process is entirely digital. The deceased CPF members next of kin who are residing overseas can submit the application to the PTO via the PTO's online application form, together with any necessary supporting documents to evince or substantiate their position, including and proving their familial relationship. Payments will also be disbursed electronically via TTs or demand drafts, if they prefer, or whichever other method, to their overseas account. So generally, the answer to Ms. Jaafar's question is that we will take proactive steps within reasonable information to identify these beneficiaries overseas, and will also try and facilitate in as easy as possible the distribution and disbursement of sums to them. Mr. Louis Ng suggested publishing guidelines or framework to help beneficiaries understand how much funeral expenses the public trustee typically agrees to defray. To Mr. Ng's question, relevant information on the PTO's disbursement of funeral expenses is already currently available on the PTO's website. The reimbursement of funeral expenses out of a deceased member's unnominated CPF monies is capped at 6,000. Eligible beneficiaries who intend to claim for the reimbursement of funeral expenses from the deceased CPF members' unnominated CPF monies may do so by submitting the relevant funeral disbursement form with the appropriate supporting receipts and so on, after obtaining consent from the rest of the beneficiaries. Mr. Ng also suggested allowing the public trustee to reimburse reasonable funeral expenses to a wider class of beneficiaries who might have incurred these expenses in good faith. Under the CPF Act, the public trustee has the duty to distribute unnominated CPF monies only to eligible beneficiaries. By extension, reimbursements for funeral expenses can only therefore be made to eligible beneficiaries and not to a wider pool beyond what the statute provides. Such a requirement serves to protect the interests of the deceased CPF members' eligible beneficiaries when the cost of funeral expenses is being claimed. And this also alleviates the risk of the PTO making payment to a claimant whom the eligible beneficiaries might well dispute the entitlement of the payment to. So with that, I believe I have addressed the questions raised in relation to the BR scheme and the unnominated CPF funds. May I seek members' clarifications on this point, if any, before Minister Tan proceeds to address the other issues raised by members on the two bills?
Clarifications, please. Ms. Aniso.
Thank you, Minister, for the clarifications. I have two questions. Firstly, is in relation to, my Minister shared in relation to, upon receipt of letter, the parties will identify and choose a representative. if they are unable to reach an agreement, then the current standard claim process will apply. In this regard, I wish to check whether the PTO can consider offering an alternate dispute resolution process, for example, through a mediation where parties are able to identify and agree on a representative so that the matter can still be processed expeditiously. That's the first question. Second one is identifying locating the beneficiaries, whether the PTO will consider perhaps to find out whether the beneficiaries have any pay now accounts and actually explore for the funds to be transferred through that manner. Thank you.
Thank you, Ms. Ho. On your first point, to the extent possible, the PTO will obviously try to facilitate. I think it is in everyone's interest, including the PTO, to try and find a solution and find consensus on a BR so that the process can be simplified and expeditious. Failing that, the member knows that there are a number of options for mediation for the parties to come to a consensus. It's not always standard and not always easy for every such situation because the reasons for the conflict may differ from case to case. But to the extent possible, PTO will try to facilitate. And on the member's suggestion on PayNow, obviously, given the range of different electronic options I've outlined earlier, we will certainly consider PayNow or any other electronic payment platform options as viable alternatives. Thank you.
Any other clarifications? Mr. Tan See Leng. Leader of the House.
Mr. Speaker, may I seek your consent and the general assent of members present to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order number 48.8 to remove the time limit in respect of Minister Tan See Leng's speech.
I give my consent as the Leader of the House of the general assent of the members present to so move. Leader, please proceed.
Mr. Speaker, I beg to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order number 48.8 in respect of Minister Tan See Leng's speech.
Question is, as moved by the Leader of the House, as many as of their opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Minister.
Thank you, Leader. Mr. Speaker, sir. Let me begin by thanking members for their suggestions and support for the Retirement and the Re-employment Amendment Bill and the CPF Amendment Bill. There were many points raised reflecting the wide spectrum of views and the common interests we share in supporting our senior workers and our fellow Singaporeans. Allow me to make a few general points before I address specific comments from members on the bills. I thank members for their various suggestions on CPF as well as our retirement and re-employment policies. We constantly and continually review our policies and we will take members' suggestions into consideration. Members recognize that legislation is not everything, and the speeches have touched on the need to adjust our culture and our mindsets, both as a society and as businesses. Members also touched on important questions which the tripartite work group on older workers had deliberated on extensively. In doing so, they considered the many perspectives which emerged from their public engagements before arriving at their very balanced recommendations. On the issue of whether a statutory retirement age is still needed, as highlighted by Mr. Yip Hon Wing, Ms. Sylvia Lim, and Associate Professor James Lim, the work group had considered this very carefully. It looked at the experiences of other countries and found that countries without the equivalent of a statutory retirement age do not necessarily have better employment rates for senior workers, despite some of them having anti-discrimination legislation already in place. Some progressive employers may take the initiative to abolish their internal retirement ages and allow workers to work for as long as they wish. And we wholeheartedly applaud them. But as Mr. Heng Chee Hao emphasized, the statutory retirement and re-employment age is still important as a floor and safeguard against employers who might not be as progressive. The continued relevance of this approach is borne out by facts. Singapore's average effective retirement age has risen faster than the OECD average. These considerations and the data that support them are captured in the work group's comprehensive report, and I encourage all members to study the report. On the pace of implementation, the tripartite partners negotiated this very carefully before arriving at a consensus. The plan to raise the retirement age and re-employment age to 65 and 70 respectively by the end of this decade is ambitious, but it is achievable. The first increase will take place in July the 1st, 2022, and is on schedule. Now, the timing of future adjustments will depend on prevailing economic conditions, but the resolve to stay the course is clear. Mr. Louis Ng asked why the range of retirement age that the Manpower Minister can prescribe in the law is being reduced from the 62 to 67 years to 62 to 65 years. Members of the House, before 2012, the concept of re-employment had not been introduced yet. So the only lever we had was the retirement age. But since then, we have seen how the concept of retirement age and re-employment age works well in combination. So after consultation with stakeholders, the tripartite partners have agreed to continue with this strategy. And beyond raising the retirement age to 65 by 2030, they've also agreed to raise the re-employment age to 70. The proposed legislative amendments thus fully reflect the tripartite consensus on this roadmap. This is our model. Tripartite consultation with stakeholders, tripartite consensus, and then tripartite implementation with legal changes to reflect the plan. Now, we do not rule out future changes to our approach, and this model of constructive tripartism will ensure that we're able to adapt and to respond to such needs in the decades to come. Mr. Sharil Taha, Mr. Yip Hon Wing, Ms. Ng Ling Ling, Ms. Joan Pereira, and Ms. Mariam Jaafar have spoken on the need to ensure that employers fulfill their re-employment obligations and that re-employment offers are fair. I agree. And the system has worked well for us thus far. Tripartite partners have agreed upon a reasonable set of guidelines, laying out employers' and employees' responsibilities. I will just highlight a few guidelines that are more relevant to the situations that members have raised. First, early communication and discussion is critical to ensure that re-employment offers are reasonable to both parties. The tripartite guidelines on the re-employment of older employees make clear that employers should engage employees at least 6 months before they reach retirement age. Second, on the issue of medical fitness, they should offer re-employment to eligible workers who are medically fit to perform any job within the company, not just the existing job role. Employers are also advised to presume that their senior employees are medically fit unless there are clear reasons to believe otherwise. To Ms. Ng Ling Ling's concern, having chronic conditions alone cannot be used to justify denial of re-employment if it does not affect their ability to perform the job. The re-employment framework is designed to balance the need to enable senior workers to continue working while giving employers sufficient flexibility so that businesses can remain nimble and sustainable. Different businesses may also face different challenges, so we must strike a very careful balance. I thank Ms. Janet Ang for sharing her journey and her views towards retirement as a senior executive. Indeed, different individuals have different needs and expectations as they approach retirement. While some may want to stay on in their current roles, others may desire a job role with reduced work intensity or see themselves trying out new roles. This is why tripartite partners have agreed that employers and employees should be given the flexibility to negotiate adjustments to the job roles, wages, and benefits as long as they are reasonable and based on factors such as productivity, responsibilities, skills, and the employer's wage system. Notwithstanding this, the vast majority of re-employed workers continue on their existing contract or a new contract in the same job. More than 95% of workers re-employed in the same job did not experience any cuts to their wage and benefits. If an employer has considered all available re-employment options within the organization and is unable to identify a suitable job for the senior worker, the firm may offer him or her an employment assistance payment or EAP as a last resort. Let me reiterate, this is as a last resort, to help the worker tide over while he or she seeks alternative employment. To Ms. Nadia Samdin and Mr. Patrick Tay's queries about the sufficiency of the EAP amount, a fine balance was struck by the tripartite work group. If the EAP is too high, it may deter employers from hiring job seekers who are approaching retirement age. If the EAP is too low, employers may too readily offer to pay the EAP. Nevertheless, tripartite partners agreed to increase the minimum and maximum EAP amounts from 1st July 2022 onwards. This is in tandem with the growth in general wage levels. Ms. Ng Ling also asked about the success rate for conciliation of re-employment disputes. After more than 10 years of implementation, we find that the majority of cases are often resolved expeditiously at mediation. This leaves a few cases that need to be surfaced to the Employment Claims Tribunal for adjudication. Mr. Shahril Taha, Ms. Janet Ang, Mr. Liang Eng Hua, Mr. Henry Kwek, Ms. Yeo Wan Ling, Mr. Gan Thiampo, Ms. Joan Pereira, Mr. Yip Hon Wing, and Ms. Nadia Samdin also highlighted ageism and discriminatory employment practices as a concern. We agree that ageism and discriminatory employment practices, we agree that ageism and workplace discrimination of any form have no place in Singapore. As members have noted in their speeches, the Tripartite Committee on Workplace Fairness, which I co-chair, is deliberating on the scope of legislation to address workplace discrimination. We are making progress in the discussions, and we hope to finalize our recommendations by the first half of 2022. I'm glad that members' speeches in this House over the past 2 days also recognize that legislation is not a silver bullet nor a panacea. In this regard, I agree with Mr. Heng Chee Hao, who has very wisely pointed out that strengthening the employability of our senior workers cannot start only when they are near retirement age. There is a need to invest in retraining and employment facilitation, not only for our senior workers, but also for the future cohorts of senior workers. As what Mr. Patrick Tay has highlighted, employers play an instrumental role in this, and we are committed to provide the necessary assistance, including financial support, funding support. To Ms. Nadia Samdin's query on the extension of the senior employment credit beyond 2022, we will also study it and update in due course. Members of the House, I've already spoken extensively on the various ways that the government is supporting upskilling and employment opportunities for senior workers in my response to several parliamentary questions last month. So today, I would just highlight the critical roles that our tripartite partners, NTUC and SNEF, play in this endeavor. The Company Training Committees, or CTCs, established by NTUC early this year are making their impact felt. The CTCs bring together the employers, HR, and employee representatives to identify gaps and opportunities and develop the necessary training plans to align a company's workforce to its business transformation roadmap. This ensures that our senior workers' training needs are correctly identified to enable them to contribute productively for many more years to come. As highlighted by Mr. Shahril Taha, Mr. Abdul Samad, and Ms. Janet Ang, it is also important for companies to have structured career planning conversations with their employees, especially for those in their 40s or 50s. This allows training needs and suitable job roles to be identified early. Employees will also be more motivated to pick up new skills if they have a clearer picture of how they fit into their company's future plans. We are working with both SNEF and NTUC to encourage more employers to do so. Now, there are many other areas where tripartite partners have been working closely on, including encouraging job redesign and flexible working arrangements, which Mr. Yip Hon Wing, Mr. Shahril Taha, Mr. Henry Kwek, Mr. Liang Eng Hwa, Mr. Patrick Tay, Mr. Ang Wei Nen, and Ms. Nadia Samdin have raised. We encourage tripartite partners to do more, and we will continue to give our fullest support. Even as we make these legislative changes today, we will also continue to work with tripartite partners to study best practices and review our framework where necessary to ensure its continued relevance. As mentioned by Mr. Sean Huang and Ms. Yo Wan Ling, it is also important for our workers to adopt a lifelong learning mindset. Continuing education and training, or CET, is just as important as pre-employment training, PET, as a means for our workers to upgrade their skills, to remain relevant, and to keep pace with global trends and developments. Let me now address members' points on the CPF Amendment Bill. First, in response to points made by Mr. Yip Hon Wing, Mr. Liang Eng Hwa, Ms. Cheryl Chan, and Mr. Gan Thiam Poh, let me reiterate that the proposed amendments to the CPF Act will not change the rules for the CPF lump sum withdrawals or other social support schemes like Silver Support. On CPF withdrawals, Mr. Abdul Samad and Associate Professor James Lim suggested to allow members to start their CPF monthly payouts earlier, while on the other hand, Mr. Satyandi Supat suggested to start later. First, let me reassure everyone that the government has not suggested changing the payout eligibility age. The payout eligibility age, or PEA, is not linked to the retirement or re-employment age. The current payout eligibility age, or PEA, of 65 strikes a balance between timely access to retirement income and providing a sufficient runway for members to build up savings for retirement, especially as Singaporeans are expected to live longer. Members continue to have the option to defer the payouts for higher monthly payouts. In fact, yesterday I shared that for every year that they defer after 65, that increase could be up to 7% more per annum. Members they will also continue to have the flexibility to make lump sum withdrawals from age 55, years before they start their monthly CPF payouts. The banker friend that Associate Professor James Lim has, and I believe is likely to be as successful as Professor Lim himself, will be able to withdraw amounts well above the retirement sum at 55. This includes the 5,000 he can withdraw unconditionally and the amounts in excess of his basic retirement sum, given that he will likely own a property. Similarly, the amendments to Section 15 of the CPF Act are only intended to simplify it and not alter the underlying policies and operational flexibilities. Mr. Louis Ng, Ms. Ng Ling Ling, Mr. Saktiandi Supat, Ms. Cheryl Chan, and Ms. Yeo Wan Ling asked what constitutes a significant condition in the bill. Today, members with conditions of any kind, including autoimmune or neurological diseases, can qualify for early withdrawal of CPF savings if they are certified by a doctor as having a reduced life expectancy or being permanently unfit to work or lacking mental capacity. These are now collectively referred to as significant conditions. The bill provides for these same grounds to be prescribed in the regulations. Therefore, there are no changes to the qualifying rules for early CPF withdrawal. I thank Ms. Yeo Wan Ling for observations on how decisions could be communicated to CPF members and would like to assure that the CPF board will certainly be mindful of her concerns. To Ms. Hertingru's point, I would like to clarify that members with reduced life expectancy will indeed be able to benefit from the automatic disbursement of ordinary and special account monies that I mentioned in my speech yesterday. On Ms. Ng Ling Ling's suggestion to allow waiver of loan repayments under the CPF Education Loan Scheme for such members, I'm happy to confirm that the CPF board already does so today on a case-by-case basis. In simplifying the CPF system, the CPF board will also ensure that implementation is smooth for its members. On the top-up rules and position of givers, the CPF board will take into account Ms. Louis Ng's and Ms. Joan Pereira's suggestions. I do believe that Singaporeans top up to their loved ones' CPF accounts out of the generosity of their hearts and to help boost their loved ones' requirement adequacy. This simplification should therefore not discourage top-ups. The objective is to simplify things for members in response to feedback that the existing rules today can be confusing. Some top-ups are refunded to givers when their recipients exit the CPF system, while, as Mr. Saktiandi Supat observed, other top-ups are treated as gifts to recipients and not refunded. including cash top-ups made after 2008. Mr. Louis Ng, Mr. Saktiandi Supat, Ms. Mariam Jaffar, and Ms. Henny So spoke about facilitating the disbursement of nominated monies. The CPF board already reaches out to nominees, including those overseas, once it is notified of a member's death, and it disperses the monies within a month, having allowed time for medical institutions to deduct any medical bills from the deceased member's Medisave account. Nonetheless, the CPF board has plans to continuously streamline the disbursement process for nominated CPF monies. And I thank Ms. Henny So for her suggestion on this. Now, beyond simplifying policies and streamlining processes, the CPF board will also continue to strengthen its public education and outreach efforts, as Mr. Melvin Yong and Ms. Cheryl Chan highlighted. This will include educating members on the benefits of CPF top-ups to self and loved ones, nudging members to make nominations, making clear that nominations, like wills, are indeed revoked upon marriage, and clarifying the treatment of CPF monies upon members passing, as alluded to by Mr. Gan Thiam Poh, Mr. Saktiandi Supat, Ms. Henny So, and Ms. He Ting Ru, as well as Ms. Joan Pereira, respectively. We will also explore Ms. Henny So's suggestion to send notifications to divorcees to prompt them to review their nominations. Now, several members of the House have provided feedback on policies that are not quite within the scope of today's bill. For example, Ms. Ng Ling Ling, Ms. Cheryl Chan, on the allocation of monies across the different CPF accounts, Mr. Yip Hong Wing on the basic retirement sum, Mr. Ang Wei Neng and Mr. Gan Thiam Poh on housing issues, Mr. Patrick Tay and Ms. Cheryl Chan on self-employed persons, as well as Mr. Saktiandi Supat on tax-approved group corporate retirement plans. The government will take all these into consideration as we review our policies from time to time. Finally, on the raising of CPF contribution rates for senior workers, I thank Mr. Henry Kwek, Mr. Ang Wei Neng, and Mr. Edward Chia for their support on our longer-term plans, including the eventual full contribution rates for workers aged between 55 to 60. The government will support employers through the CPF transition offset, which Mr. Heng Chi Hao, Mr. Melvin Yong, Mr. Gan Thiam Poh, and Ms. Nadia Ahmad Samdin have all touched on. This will be implemented on the 1st of January 2022 as part of the Senior Worker Support Package. This is in tandem with the first increase in CPF contribution rates for senior workers. In closing, I would like to thank members of the House for their support of the bills. The two bills will help our members in three main ways. First, it will provide members the flexibility to work longer if they wish to. Second, by making it easier for members to build up their retirement nest egg. And third, just as important, by making it easier for members to receive their retirement payouts. Together, the bills will help our members better prepare for and enjoy their retirement. But the work does not stop here. We are confident that further progress on senior worker employment will be made, and we will continue to simplify rules. We will continue to improve communications to our CPF members. With the support of the members of the House, businesses, unions, and most importantly, fellow Singaporeans, we will be a more inclusive economy and society. Mr. Speaker, sir, I beg to move.
Clarifications, please. Mr. Willem.
Thank you, Mr. Speaker. I have a clarification for Minister regarding the statutory retirement age. Earlier, he mentioned that the consensus among the tripartite partners was that this was still necessary on the statute books as it serves as a floor to protect workers. My question is that most, if not all, employment contracts, as I mentioned in my speech, do have a termination clause where either employer or employee can give notice of a short period, 1 to 2 months, to stop the employment relationship, and no reasons need to be given. And if notice is not sufficient, payment in lieu can be made in accordance with that clause. So, would you not agree that actually that clause can be exercised at any age of the employee? And to that extent, my question is, how far does having a statutory retirement age in that sense undermine the operation of that clause which is in the contract? Thank you.
I thank Ms. Silva Lim for her question. Indeed, I'm aware of the fact that many companies, especially those hiring those with the senior management employees, for instance, have this clause which puts many workers on fixed employment contract terms. I think we should look at it from different angles. At the point of the recruitment, particularly when his tenure, based on that fixed contract has expired, and if he's looking for a job, and if he's, say, within 3 to 5 years of the statutory retirement age, no company should deprive him of the opportunity of being employed because of the fact that he's near, he's near the statutory retirement age. That's the first point. On top of that, if an employee has been dismissed on grounds of age, and if they believe so, this retirement age allows the employee to appeal to the MOM to look into it and to investigate whether there were grounds. To your point about many of these contracts being fixed term contracts, it is also one of the broader perspective that the tripartite committee that's set up on the legislation part of age discrimination in the workplace is something that we will also be diving deeper into and looking as well. Thank you.
Ms. Abdul Samad.
Mr. Speaker, thank you, Minister, for the clarification. I'm requesting in regards to the eligibility payout at 65. Firstly, as I said in my speech, I'm not also here wants to encourage people to work till their last breath. Does the MOM actually does a study, how many of those actually choose to retire early, maybe because of age, or they just want to retire early, and hence, can they actually ask for their CPF payouts to be an earlier age compared to at 65? That was the main gist of me requesting for the ministry to explore the possibility if someone decides to retire before the legislative age, because I want to do something personal, and it's actually to them is their money, and they also are requesting whether you can get part of the share. Thank you.
I thank the member, Mr. Abdul Samad, for his question. Perhaps if I can use an illustration, at 65, the member can withdraw a guaranteed sum of $5,000, of course, provided he has the money in his CPF account. He can withdraw a sum of $5,000. Now, in the retirement account, he's expected to have the basic retirement sum. I believe today it's pegged at it's 93,000. And if his house, the house is pledged, which I believe the property, most Singaporeans today would have, the majority of Singaporeans would have a property, and it's pledged to the CPF, he can not just withdraw the $5,000 at age 55, he can also withdraw a sum higher than that $5,000 from his special account and the ordinary account. That is what is current today. Now, if he has the full retirement sum set aside, the FRS, which is double that of the basic retirement sum, I think it's now 186,000, so 93 times 2, he can withdraw, and if he doesn't have his housing pledge, his house pledge to the property pledge to the CPF, he can withdraw, again, the minimum of that $5,000 and amounts in his special account and also the ordinary account. So this PEA, or the payout eligibility age set at 65, is really reserved for the amount, the BRS or the FRS, in his retirement account to stream out the monthly payout starting from 65. And for those that are born on or after 1958, this will go into CPF Life, and it will be streamed out as an insurance. It's like an insurance annuity that will be paid out for life every month. So I hope that that explains the stance. So now, where are any of the changes that we are proposing today, and I hope that members will support, now where has it changed any of the dynamics whatsoever? The members can still withdraw their money from age 55 onwards, but subject to those conditions that are already in existence today. Thank you.
Any other clarifications? The question is that Parliament will immediately resolve itself into committee of the bill. As many as of the opinion say aye. Oh, hang on a second. Skip the line. Yeah, sorry. Let me repeat that. The question is that the bill be now read a second time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The Retirement and Re-employment Amendment Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
Question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 7 send part of the bill. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Manpower.
Mr. Speaker, sir, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
Question is that the bill be now read a third time. As many as of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The Retirement and Re-employment Amendment Bill. Item 2, the Central Provident Fund Amendment Bill, second reading.
Minister for Manpower.
Mr. Speaker, sir, I beg to move that the bill be now read a second time. The CPF Amendment Bill 2021 is linked to the previous bill in our order paper, the Retirement and Re-employment Amendment Bill 2021. In the debate we've just had on that bill, I've explained the amendments proposed in both bills. Members have already raised their questions and expressed their views on both bills during the earlier debate, although they are still welcome to do so now if there are any additional questions or views. Mr. Speaker, I beg to move.
The question is that the bill be now read a second time. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The Central Provident Fund Amendment Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 68 stand part of the bill. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Manpower.
Mr. Speaker, I beg to report that the bill has been considered in the committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
Question is that the bill be now read a third time. As many as of the opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
The Central Provident Fund Amendment Bill.